As Shannon said, I'm joined today by Erin Moyer. Erin was my paralegal in my bankruptcy practice for 7 years.
Yeah.
And Erin knows this stuff cold. She knows every clerk's office. Every clerk knows her around here. When she calls up, they know she knows what she's talking about. She frequently corrects them because of the stuff that the clerk's office does tend to screw up from time to time. But we all make mistakes. We all have to make amendments to our paperwork. I thought it would be particularly helpful, since today is going, after the first topic, today is really going to focus on the paperwork, that you get the benefit of someone who has years and years and years of experience working with clients on getting the paperwork filed. So, the first topic I want to talk about today is discharge. Before I do that, somebody asked at the end of last session about the credit counseling agencies that were approved to give credit counseling and financial management courses in DC. And I mentioned that I thought we were going to have a handout today. We don't, because it happens to be in your written materials already under the credit tab. That's where you will find the list of all of the approved credit counseling agencies. These are the agencies that are approved to give the pre-bankruptcy credit counseling course and the post-bankruptcy or during bankruptcy financial management course. Okay. So we do have a handout, but we're not going to give it to you because you already have it. In any event, okay, let's talk for a moment about discharge and dischargeability so that we can get to the important stuff about completing the paperwork that drives a bankruptcy case. Like we talked about, the object of a Chapter 7 is to ultimately obtain a discharge from the debtor's obligations. And let's talk about what the discharge is. Just like the automatic stay, which is an automatic statutory injunction barring creditor action, the automatic stay is a temporary injunction that runs essentially the length of the bankruptcy case. What it's replaced by is the discharge, and sometimes you hear it referred to as the discharge injunction or the injunction of the discharge, because it is effectively a permanent automatic stay. It is a permanent release, abatement, waiver, whatever term you want to use as an synonym for discharge. The bankruptcy discharge is that with respect to the personal liability that the debtor has for the debtor's debts as of the date of the filing bankruptcy, as of the petition date. You remember we said that the petition date creates a pre-petition and a post-petition period. The discharge only discharges pre-petition debts. So if you have a debtor who a week after the bankruptcy petition is filed borrows money from a relative because that particular week they were short on an insurance premium or a utility bill, that post-petition debt is not covered by the discharge. Only pre-petition debts are covered by the discharge. So that's the first thing about the discharge. The second thing about the discharge is that it is entered now automatically when certain time periods elapse. It used to be, back in the 80s, we had what was known as the graduation ceremony. And this was where all your Chapter 7 debtors would show up in court, and they would typically do 20 or 30 of these at a time. And the judge would come out and would read them a canned speech about the impact of a discharge on their lives, what it means to have a discharge, what the limitations as a result of getting a discharge might be. And then the judge basically says, okay, stand up and go home. And that was it. And the conclusion was this was just a colossal waste of time. And so they stopped doing the graduation ceremony in the interests of further streamlining and expediting and simplifying the bankruptcy process. So there is no opportunity in your typical bankruptcy case to ever get in front of the judge. You remember we talked about the meeting with the trustee that occurs about 5 weeks after the bankruptcy petition is filed. That's called the 341 meeting or the meeting of creditors. And now you have a discharge that's entered automatically without having to go to court to go through this graduation ceremony. So in your typical Chapter 7 case, you're never going to see the judge. And that's a conscious decision that was made by Congress when it adopted a Chapter 7 process and made further amendments to that process to simplify it and streamline it and not burden the courts with administrative things like overseeing 341 meetings, which it did under the old bankruptcy law, or having this ridiculous graduation ceremony, which was the way we started out but figured out that wasn't going to work. One of the things your client will probably be very worried about is having to go to court. Do I have to go to court? And the answer is, in most cases, overwhelmingly the majority of consumer bankruptcy cases, no, you don't. You have to have some kind of a dispute, whether it's a dispute over the exemptions, whether it's a dispute over venue, whether it's a dispute over eligibility, whether it's relief from the automatic stay that a creditor seeks and the debtor wants to contest, that you even have the opportunity to have a court hearing on something. But otherwise, your typical Chapter 7 case does not involve ever going to court. For those of you who were thinking that by taking on bankruptcy cases, you'd be able to go to bankruptcy court, sorry, you're going to have to get a screwed up case in order to get into bankruptcy court in your routine Chapter 7 cases. Okay, the discharge is, as I said, it's a permanent injunction that bars all creditor action. But as you can imagine, there are policy decisions that were made with respect to the scope and breadth of that discharge. A conscious decision was made by Congress and by multiple Congresses, because this has been true not only under the current bankruptcy law, but under the preceding bankruptcy law, to exclude certain kinds of debts from the discharge. And as I mentioned on Tuesday, these are referred to colloquially as non-dischargeable debts. And the contest over whether a debt is or isn't dischargeable is called a dischargeability fight. So as we compound the word discharge even more, there are proceedings, which we'll talk about in a few minutes, over the non-dischargeability of debts. There are certain debts which Congress said are going to automatically be excluded from the bankruptcy discharge. And there are certain kinds of debts which are disputable, which require the bankruptcy court's determination as to whether or not they are dischargeable or not. And these are things that, as we talk about them, are going to seem fairly logical. Now, you remember on Tuesday I drew a distinction between the dischargeability of a particular debt versus whether or not the debtor is entitled to a discharge at all. And let me tell you, there are different statutes that govern those different things. The dischargeability of a debt is determined by Section 523. And you will hear about 523 actions and 523 deadlines. If you hear reference to 523, it is because there is some issue related to the dischargeability of a particular debt. The Bankruptcy Code section that governs the ability of a debtor to get a discharge at all, or to have his or her or their discharge barred entirely, is Section 727. And you will hear reference to a 727 action or a 727 deadline. You will hear a reference to barring a debtor's discharge or an action on the debtor's discharge. And that is an action that would be filed to prevent a debtor from getting a discharge from all and any of the debtor's debts, without regard to the nature of the debts. Actions under 727 don't depend on the nature of the debt in order to have the discharge barred. It relates to the conduct of the debtor during and preceding the bankruptcy case in order to get or lose their ability to get a discharge. Section 523 has a whole long list, and we've reproduced it under significant statutes in your materials, has a whole long list of the kinds of debts which are not dischargeable or are non-dischargeable debts. Some of them are going to be pretty obvious, and most people and most of your clients are going to know and understand this in advance. So for example, and we're not going to go in detail through all of these, but I want you to understand what they are, things like student loans. Student loans, it used to be that if a student loan was more than 5 years old, it was dischargeable, then they raised it to 8, then they raised it to 10, and now the answer is, if it's a student loan, it is not dischargeable at all automatically. End of story.
Well, not thoroughly the story. Aren't there some exceptions for extreme hardships?
Yes.
Yeah.
There is an exception to the exception for student loans, which is that if the perpetuation of the debtor's liability for a student loan would constitute a hardship on the debtor, then the court may determine under the specific facts of that debtor's circumstances that the debt is dischargeable. As it has developed under case law, the bar for determining that a student loan is dischargeable is absurdly high. We have had cases where literally the debtor was mentally ill, but since the debtor was found to be able to do things like piecework, assembling things, and earn money, that the perpetuation of a student loan would not be a hardship. You literally, and there are cases like this, you literally have to have somebody who has $250,000 of medical school loans, was in a car accident, and is paralyzed from the waist down so that they cannot practice the thing or do the thing for which their student loans represent an educational obligation, in order to get a court to recognize a hardship. It is a terribly high burden. So what we tell people, especially if they're sitting across from you at your conference table, is student loans are not dischargeable. If you've got someone who's got such an extreme situation, then you can ask the bankruptcy court to make a determination that the student loan should be discharged. But if somebody has walked into your office and sat down, then the odds are extremely low that you're going to convince a court to do it. And we have seen cases where someone claimed, well, you know, I have $100,000 for my art history degree from Vassar and I can't get a job. And the courts say, you can get a job. It might not be in art history, but you can get a job. That's not good enough. I lost my arm serving in Afghanistan. Well, you know what? You can go teach. You can work at the War College. You can get a job. And therefore, your student loans are not dischargeable. It is just absurdly high. There was a survey that was done, I think about 6 or 8 years ago, and they found that out of something like 658 attempts to discharge a student loan, 12 were successful. So, and that accounts for the screening that lawyers do to determine whether or not it's even worth fighting. 658 times, whatever the number was, the lawyers thought it was worth a shot, and they only won 12 times. So it's for all intents and purposes, student loans are automatically not dischargeable. And as I said, the word is out, because I have yet to run into an individual client who didn't already know that they couldn't get out of their student loans. Another kind of debt that is automatically excluded from the discharge, is automatically non-dischargeable, are debts which are not listed and don't get notice of the bankruptcy. If you don't get notice of the bankruptcy, it is unfair to bind you to the discharge because you have not had the opportunity to participate. All right, this requires some explanation because in DC and in Maryland, and in several of the courts around the country, but at least in DC and Maryland, there is a very peculiar and very complicated issue with exactly this category of non-dischargeable debts. If you have trouble following this, make me explain it until you get it, because it is critically important. When a bankruptcy case is filed, a Chapter 7 case, there is sometimes, not in every case, but there is sometimes established a deadline for creditors to file their claims with the bankruptcy court. The way creditors do this is by filing a form, an official form, called a proof of claim. And you remember I told you that the mailing matrix that you file with the bankruptcy court is what the bankruptcy clerk's office uses to send notice to creditors of the filing of the case number, the identity of the trustee, the location of the meeting of creditors, and the date and time of the meeting of creditors, along with some other deadlines. Well, one of the other deadlines that is set in that notice is the deadline that creditors have to meet in order to file their proofs of claim. This is also called the bar date, because claims which are not filed by the bar date are treated as the last claims. They are subordinated to and are the last claims to be paid. If you file a claim but not on time, you go to the back of the line. If you file on time, you get to participate with the other timely filed claims in Chapter 7 in any distribution. So in some cases, a bar date for the filing of proofs of claim is established, and creditors get notice of it in that notice of the commencement of the case and the notice of the meeting of creditors. A bar date is not set in every case. The reason is that the clerk will look at the paperwork that is filed and will make a determination based on the paperwork, and specifically based on one box in the voluntary petition, which we'll be talking about in a few minutes. And if the clerk determines, based on the paperwork, that it does not appear that there are going to be assets for a Chapter 7 trustee to administer, meaning that there won't be any cash for the trustee to distribute to creditors, the clerk will not set a bar date for the proofs of claim, because there's no purpose filed. There's no purpose satisfied in the filing of proofs of claim where there isn't going to be a distribution. So in many, many cases, a bar date for the filing of proofs of claim is not set. In some cases, where the paperwork, the initial paperwork, indicates that there may be assets available, the clerk will set a bar date for the filing of proofs of claim by creditors. Okay, so you've got potentially one of two conditions. There either is a bar date or there isn't a bar date. If you look at Section 523, Section 523 says that a creditor who does not get notice of the bankruptcy is not bound by the discharge. And typically that means a creditor who is not listed in the mailing matrix and the schedules of assets and liabilities. That creditor's claim is going to automatically survive bankruptcy. But there's one qualification. If the creditor, even though it hasn't been listed in the initial paperwork or the amended paperwork, still gets notice of the bankruptcy filing in time to file a proof of claim by the deadline, by the bar date, they are bound by the bar date and by the discharge. So even if a creditor is not listed, if they still manage to get notice of the bankruptcy in time to beat the bar date, then they will be discharged when the discharge is entered. In cases where there is a bar date that's been set because it appears there might be assets, then that's simple. If a creditor gets notice before the bar date, then they have an opportunity to file a timely proof of claim, and so they are bound by the discharge. But what happens in cases where there is no bar date? That means there is no deadline by which creditors have to file a proof of claim. And here's what the court here in DC and the court in Maryland has said. In cases where there is no bar date set for the filing of proofs of claim by creditors, that means creditors have forever to file proofs of claim. Because there is no deadline, if you ever tell an unsecured creditor or a secured creditor of the existence of the bankruptcy, because there's no deadline, that means that even if it's 2 years after the bankruptcy case is over, they still have not missed the deadline for the filing of proofs of claim because there was no deadline for filing proofs of claim. So your clients may ask you, well, what happens if I forget somebody but remember after the case is over? If it's a case where there has not been a bar date set for filing proofs of claim, you simply notify that creditor of the fact that there had been a bankruptcy filed, and that creditor's claim is discharged, even though they were not listed, even though the case is over, the case has been closed, even though the trustee has finished his job and the trustee has been relieved of his obligation to serve as trustee, simply because even 2 years, 3 years, 5 years after the bankruptcy case is over, there still has not been a passage of the deadline for filing proofs of claim. So in theory, that creditor still could file a timely proof of claim. Okay, it's kind of a silly legal fiction that's been created, but the net result is if your client has a case in which no bar date has been set, then the answer is they can forever notify creditors who they may have forgotten to give notice of the fact of the bankruptcy, the case number, the chapter, the location of the filing. And even though they were not listed and their debt should be non-dischargeable because they weren't listed, they're still discharged because there was no bar date. Very, very important thing that is unique to DC and Maryland. Okay. Question?
Do you have any particular suggestion about how to notify them so you can make sure it sticks if they just go ahead and sue anyway? If they're notified?
What we typically do is we send them a copy of the notice that the clerk's office has issued officially, which is the notice that the matrix is used, among other things, to send out, which is that notice of the commencement of the case, which also includes information about the meeting of creditors, the identity of the trustee. I would send them, and we historically have sent creditors who have just cropped up that nobody remembered. We've sent them a copy of that notice, and that was good enough. At that point, it required some explanation of this peculiar glitch about the absence of a bar date, but they understood that they were bound by it, and typically that was enough to do it. It would be enough to just call them up and say, hey, listen, go look at case number 14-00256 because the person you're suing or the person you're trying to collect from, in fact, has gotten a discharge in bankruptcy.
And if it's a lot of creditors, I just go ahead and amend the mailing matrix to add those creditors that were forgotten. If there's like 4, 5, 6, 7 of them, just to make it clean and concise. And most of those are the ones I have that are 13s where you have to file a proof of claim. But for some of the 7s where they've left off a whole bunch, I'll just do it. I think it's like $30 to amend the matrix and file an amended schedule and just be done with it that way.
Okay, another category of debt that is automatically excluded from the discharge are obligations, domestic support obligations, alimony, child support. There is no need for the recipient party to come into the bankruptcy court and ask the court to determine that their domestic support claim is not discharged or non-dischargeable. That is automatic. That's 523A5 and 523A15. That has been expanded over the years to make the reference to a domestic support obligation broader and broader and broader. And what's interesting is that the courts have gone so far as to say, if you have a property division agreement between separating or divorcing spouses, and the property division is made in lieu of alimony, support, or maintenance, then even the obligations created under a property division are not dischargeable automatically because they are the equivalent of the non-dischargeable domestic support obligations for which the court sees the property division as a substitute. So domestic support obligation, automatically non-dischargeable, and it's a very broad categorization. Now, if you look under the Bankruptcy Code says there are 3 subsections of 523, and therefore 3 broad categories of debts that the bankruptcy court must determine whether or not that underlying debt is discharged and dischargeable or not. And it's 523A 2, 4, and 6. The first 3 even-numbered subsections, 523A 2, 4, and 6. And with respect to those categories, there is a deadline for bringing an action in the bankruptcy court to determine whether or not debts are dischargeable or not under 523A 2, 4, and 6. That deadline is 60 days from the meeting of creditors. If a creditor does not file an action within that 60-day period, and they are given notice of that 60-day period, they're given notice of the deadline in that same notice that the clerk's office sends out at the beginning of the case. If they don't ask for a declaration of non-dischargeability of their claim, then their claim will be discharged. The passage of that deadline is jurisdictional. You can't, after the fact, ask that the time be reopened, nunc pro tunc. Another one of those great Latin phrases I remember vaguely from law school. So if you miss that deadline, you are out of court. By the same token, if you're the debtor, you're sitting there waiting for that 60-day deadline to pass, because if no one files within that 60-day deadline, then except for the debts which are automatically not discharged, everything else is going to be discharged. The action that is brought to obtain a determination of the dischargeability of a debt is called an adversary proceeding. And you heard the clerk's office talk about adversary proceedings. An adversary proceeding is basically any piece of litigation, with the exception of motions, any piece of litigation that goes on in the context of a bankruptcy case. And that litigation is essentially run the same way as any other piece of civil federal litigation. There is a complaint, there's an answer, there are, the equivalent of Rule 12, 12B 1 through whatever it is, 6, 7, that defenses that are available. There are the pleading requirements of particularity for fraud. All of the same rules of procedure with very few changes govern how adversary proceedings are handled. The only issue is whether a case is, you remember this, core or non-core, whether the judge can hold a trial and enter a judgment, or holds a trial and enters proposed judgment that the district court reviews. You have things like, summary judgment, default judgments, you have all the discovery rules are applicable with certain changes. And the rules that govern adversary proceedings are in the Federal Rules of Bankruptcy Procedure in Part 7. So for example, if you have Civil Rule 12, Bankruptcy Rule 7012 is the equivalent bankruptcy procedure. If Rule 56 is the federal rule for summary judgment, Bankruptcy Rule 7056 is the bankruptcy adversary proceeding rule on summary judgment. The discovery rules show up in bankruptcy rules 7026 through 7037, those sorts of things. And you'll see in some cases, the bankruptcy rule simply adopts and incorporates the federal rule verbatim. In some cases, it'll say, Federal Rule 54A through J is hereby incorporated, and then you'll see they add a subsection K, which tweaks the rule's applicability because now you're in bankruptcy court. So Part 7 of the bankruptcy rules govern adversary proceeding, and you must file an adversary proceeding by the deadline, the bar date for the filing of complaints to determine dischargeability, or else your debt's going to be discharged if you assert that your claim is non-dischargeable under 523A2, 4, or 6. Okay, let's talk about what makes up 523A2, 4, and 6. And we're going to do it in reverse order. Under 523A6, a creditor may ask the court to determine if its claim is dischargeable or not if the claim arises from the willful and malicious and wanton conduct of the debtor. Basically, your intentional torts. If you have a claimant whose claim arises from an intentional tort committed by the debtor, then under 523A6, that debt may not be dischargeable, but it's not automatic. The creditor who holds that claim must file an adversary proceeding by the deadline in order to get from the court a declaration that its claim is non-dischargeable. Okay, that's 523A6. 523A4 says that if a creditor's claim arises from the debtor's breach of fiduciary duty or embezzlement, that it will not be dischargeable. But again, this is not something which is necessarily objectively determined, like whether or not a creditor's claim is listed or whether or not a claim is a student loan or not. So if the claim arises from a debtor's breach of fiduciary duty or embezzlement, then the creditor holding that claim must file an adversary proceeding by the deadline to obtain a declaration that their claim will survive the bankruptcy discharge and be declared non-dischargeable. And then finally, 523A2, and this is the tough one. Claims that arise from either fraud or the use of a false financial statement cannot be discharged. But if a creditor's claim arises from fraud or from the debtor's use of a false financial statement, the creditor must bring an action by filing an adversary proceeding asking for a determination that its claim is non-dischargeable on the basis of 523A2 and must do so by the deadline or that claim is going to be discharged. In bankruptcy court, the kind of fraud that is not dischargeable is a very narrow kind of fraud. Technically, something like negligent misrepresentation might be construed as fraud outside of bankruptcy court. But negligent misrepresentation is not good enough. You have to have actual, real-life fraud. By the same token, the use of a false financial statement outside of bankruptcy court, that's actionable as fraud. But a special category has been established of non-dischargeable debts on the basis that the debtors filed, for example, a loan application and made misrepresentations in that loan application. And in the context of a false financial statement, negligence is good enough. But it's only with respect to written negligent misrepresentation. You can't have a verbal negligent misrepresentation or even intentional misrepresentation that is actionable as non-dischargeable fraud. It has to be actual fraud, and if it has anything to do with the debtor's financial affairs, it's only actionable if it's in writing. So you have actual fraud or the use of a false financial statement. Verbal statements about a debtor's financial statement and financial condition are not actionable as non-dischargeable debts. It is a peculiarity of the way 523A2 has been written and has been interpreted. So it's a fairly narrow range of non-dischargeable debts as fraud or having been occasioned by the use of a false financial statement. But within those two categories, there is lots and lots and lots and lots of case law about how the use of a false financial statement, even if it's negligent, can result in non-dischargeability. You had a question?
Yeah, it's kind of on the subject of fraud. Like, say for example, if does a person's prior crimes ever come into play in bankruptcy court?
Yes.
Like, say for
Yes.
example, the person has, like, I don't know, credit card fraud on their account, and for whatever reason, I'm just asking.
Yes, absolutely. First, one of the other categories of automatically non-dischargeable debts are criminal restitution, so just make a note of that. Can't get out of criminal restitution obligations by filing bankruptcy. But if there has been, and this raises a broader issue, if there has been an adjudication in a non-bankruptcy forum, either as a result of a criminal prosecution or as the result of a civil trial, that the judgment in that other court results in a determination that the debtor committed an intentional tort, or that the debtor committed actual fraud, or that the debtor used a false financial statement, there is a collateral estoppel effect that is given to that determination if the creditor on that claim seeks non-dischargeability. So if there is a criminal conviction that a person embezzled funds, the bankruptcy court will give res judicata and collateral estoppel effect to that finding. Okay. The difference is that only the bankruptcy court can make a determination as to whether or not a debt is dischargeable or not. So the mere fact that another court, whether it's a criminal proceeding, an administrative proceeding, a judicial proceeding, a proceeding before the tax court, it doesn't matter whether or not any other court has made a determination that the debtor's liability is predicated on fraud or embezzlement or an intentional tort, because the bankruptcy court still has to determine whether that judgment fits into one or another category under 523. So you may get some collateral estoppel or res judicata effect from a judgment in another court, but you still have to come to bankruptcy court and file an adversary proceeding on the basis of that other judgment to get the bankruptcy court to declare that, yes, that judgment fits into one or another category under 523 to be non-dischargeable for bankruptcy purposes. So sometimes you will see debtors who have been sued for fraud, and they're in the middle of trial, and they come up to the eve of trial, and before there is an adjudication at trial of their fraud, they file bankruptcy. Why? Because they don't want the bankruptcy court to be bound on the underlying question of fraud by virtue of a judgment from another court. They want to be able to retry the whole fraud issue if the creditor seeks a determination of non-dischargeability. So very often we have seen parties against whom potentially non-dischargeable claims are being litigated in a non-bankruptcy forum run to bankruptcy court to prevent that state court or that other tribunal from getting to the point where it enters judgment. And we've seen the same thing with motions filed for summary judgment. On the eve of hearing, they file a bankruptcy to prevent the entry of summary judgment, which precludes their ability to retry the issue in bankruptcy court in an adversary proceeding designed to declare that claim non-dischargeable. Yes?
So you have to file to have to gain a declaration of non-dischargeability. So to say it as non-dischargeable, it indeed is dischargeable if you don't file by that party.
That's correct.
So you can, debtor can still get out of that debt.
Absolutely. If the creditor fails to file timely a complaint to determine dischargeability, the debt's discharged.
what you'll see a lot of the time is the creditor is trying to figure out if they can file an action, so they'll actually ask the court to extend the time period that they have to file that action. So usually they'll come to counsel and ask if they consent to extension. They can continue to extend it while they get their pieces of the puzzle and they're doing their research. That's when you kind of know you probably have something coming if they're gonna ask you to extend the time because they can't get it done in the 60 days that they have.
So if the bar date gets extended, is it just for that one particular creditor or is it for everybody?
It depends on what they ask for and who asks for it. For example, if the Office of the United States Trustee asks for an extension, it's going to apply to everybody. If a particular creditor comes in and says, I would like the deadline extended, it's only going to apply to that creditor, unless the court says, you know what, I'm not just going to extend it for you, I'm going to extend it for everybody. If the U.S. trustee asks, it's going to be for everybody. If a particular creditor asks, typically it is just for that creditor. A request for an extension of time must be made within the 60 days. You can't do it after the fact because that deadline is jurisdictional. If you're going to seek an extension of time, or if a creditor is going to seek an extension of time, the creditor better have been doing something along the way to show that it's working on its complaint or doing research or an investigation, but it's doing something along the way to show that it is in good faith pursuing the potential filing of a complaint to determine the dischargeability. Now, typically extensions are not contested. The bankruptcy courts tend to be fairly liberal on giving creditors additional time. But, excuse me while I pat myself on the back, I had a case in Alexandria. I was representing the debtor, and on the day before the 5/23 deadline was set to expire, a creditor filed a motion to extend the time for another 60 days. This creditor had done nothing up to that point in the bankruptcy case. They never sent me a single letter or made a single phone call to me asking me for a single piece of paper, never made any inquiry of me or the debtor about any aspect of their claim, never showed up at the meeting of creditors and did not ask questions at the meeting of creditors, and basically did absolutely nothing until the 59th day when they said, oh my God, there's a deadline, let's file a motion to extend it. So case law has developed that says if you've done nothing during the entire period of time, remember, it's 60 days from the meeting of creditors, and the meeting of creditors doesn't occur until several weeks after the case is filed. So it's not that they didn't do anything in that 60 days. They haven't done anything since the case was commenced, weeks before that meeting of creditors. The bankruptcy court said, where the cases have said, a creditor must show that it's doing something in that time period. Because this creditor did nothing, we are not going to extend the deadline. And because the deadline had already passed, they filed their motion on the next to last day. So by the time it came up for hearing, it was beyond the deadline. The court said, sorry, too late. I'm not extending the deadline, and now it's too late because the deadline passed and it was jurisdictional. So you're out of court. My client got a discharge from a debt that probably would have been declared non-dischargeable simply because the creditor did nothing. So if you ever find yourself in a situation where you represent a creditor with that kind of claim, do something. Show up at the meeting of creditors, send a letter, do something. Doesn't have to be extensive, but do something. And if you're representing a debtor and some creditor tries that nonsense, where on the 58th day, 59th day, 60th day, they file a motion saying, oh, we need more time. If they haven't done anything, oppose it. Make the creditors work. Okay. So that's 523. Non-dischargeable debts. If you don't ask for a declaration that a debt supposedly non-dischargeable under 523, 2, 4, or 6 is non-dischargeable, then it will be discharged. There's a 60-day deadline from the first date of the meeting of creditors, If it's not met, it's jurisdictional. It can be extended, but it has to be extended for cause. And the cause is that the creditor has started doing something but has not yet completed it. Okay, so that's dischargeability, yes?
Is there any record notice portion of this? That a creditor, unless he's paying attention, just is on record notice, doesn't file just because he doesn't see it?
Well, two things govern that. The first is that creditors, if you have done your job with your debtor, all of those potential creditors should be listed and should have gotten a notice from the bankruptcy court at the commencement of the case, advising them of the filing of the case number, the location, the chapter, the ID of the trustee, as well as that bar date. So that's one thing. The second thing is the record of a bankruptcy proceeding is considered public record, which means that, at least in theory, everybody's on notice of what's in that record. So if there's some kind of knowledge or notice that a creditor can be charged with, then they are also charged with notice and knowledge of that bar date. Okay, that's 523, the non-dischargeability of a particular debt. By contrast, you have Section 727, which governs proceedings to bar a debtor from receiving a discharge at all. Procedurally, an action to bar a debtor's discharge is exactly the same and runs on the same timeline as an action under 523. The deadline will be the same in virtually every case to file a complaint to bar a debtor's discharge under 727 as under 523 to determine dischargeability. And the procedure is the same. You file a complaint initiating an adversary proceeding seeking to bar the debtor's discharge. And it proceeds as an adversary proceeding under the bankruptcy rules, Part 7 of the bankruptcy rules, which govern the way in which adversary proceedings are handled. So it's exactly the same as a 523 case. Obviously, there's a difference in substance because a 727 action, a bar to discharge, is not fact-specific to a claim. It doesn't depend on the nature of the claim. It depends on the conduct of the debtor. And when you look at Section 727, you will see a whole bunch of categories of acts that can be committed by a debtor which will justify barring a debtor from getting a discharge at all. And we're not going to go through all of them, but I'm going to give you a couple of the examples. The first is making a false oath, basically lying under oath. The debtor has lots of opportunities to do things under oath. Remember, the paperwork we are going to be talking about the rest of today is all signed under penalty of perjury. When the debtor has the meeting with the trustee, the debtor is sworn in as a witness to testify at the meeting of creditors under oath. If the debtor is found to have lied under oath in the paperwork or in the testimony, then a party in interest can come in and ask the bankruptcy court to bar the discharge under Section 727A4. Clearly, a debtor who lies should not get a discharge. Okay. Another act that a debtor can commit, yes?
Now, when making these false oaths, you have to be intentional?
Yes. Yes.
So they have to show intent?
Yes.
Okay.
Another act that the debtor could commit, which would result potentially in barring his or her or their discharge, is having made transfers of property in contemplation of bankruptcy for the purpose of keeping that property out of the hands of their trustee and out of the reach of creditors, basically making an intentional fraudulent conveyance in contemplation of bankruptcy. And again, clearly the policy underlying this is pretty straightforward. You don't want debtors who are hiding their assets on the eve of bankruptcy to be able to discharge their debts. So if you look at Section 727, I think it's A1 or A2, you'll see the explicit way in which it's phrased. But if a debtor who, prior to the filing of bankruptcy, has hidden their assets, cannot get a discharge in the bankruptcy. Another thing that will prevent a debtor from getting a discharge in this bankruptcy case is to have gotten a discharge in another bankruptcy case that has been filed during the 8 years prior to this case. You will occasionally find a debtor, we refer to them as bounce backs, not serial filers, but repeat filers, who have been through bankruptcy before. And one of the questions in the bankruptcy petition is whether or not they've ever filed bankruptcy before. The reason is a debtor cannot get a discharge under Chapter 7 more than once every 8 years. The Bible calls for forgiveness of debt, I believe it's every 7 years. The bankruptcy code says 8 years. So we're really kind of doing the Lord's work here. Where you have a debtor who has been through a bankruptcy, a Chapter 7, within the last 8 years, they can still file bankruptcy. They can still get the protection of the automatic stay. And it may be determined that they have assets to distribute or not. The only difference is at the end of the case, they won't get a discharge. So they're not barred from filing. Don't make that mistake. They're not barred from filing bankruptcy. They're simply barred from getting a discharge in that second case, filed within 8 years. And what is the measure of date? It's not the date of discharge, it's the date of the filing of the first case. It's the petition date in the first case that starts the 8 years running to the petition date of the second case. If a case is more than 8 years old, it is not a bar to getting a discharge in a current case. So not only do you have to know if they filed, you have to know when they filed that first bankruptcy case. The rule is slightly different if they've been through a Chapter 13. Then it's only a 4-year bar. But if you take a look, I think it's 727A8. A9?
It says 6 years on this, in the form, for Chapter 13.
For Chapter 13, it's 6 years. You take a look at 727A9, and it gives you the computation for when a prior discharge entered in a case will prevent the entry of a discharge in the current case. Another thing that will justify a bar to discharge, and this is a little bit, I think, disproportionate, is the debtor's failure to keep books and records from which their financial affairs can be determined. Now, you're going to run into, as we've run into, countless debtor clients, individuals, who don't have copies of all of their credit card invoices for the last 3 years, who don't have all of their pay stubs for the last 2 years, who don't even have copies of their tax returns beyond 1 or 2 years back. Technically, those people should have their discharge barred because they didn't maintain records from which their financial affairs can be ascertained. So thankfully, the bankruptcy courts have established a very high threshold. It has to be something like, you don't even keep this month's credit card bill. You throw it away immediately before you ever open it. You take your bank statements, and before you ever open it, you throw it away. You purposely start throwing away all of your old tax returns in contemplation of bankruptcy for the purpose of ensuring that nobody can reconstruct what your financial affairs looked like. But there is a provision of 727 that says the failure to keep books and records is grounds to bar someone's discharge. Another thing that will justify a bar to discharge, and this is, again, it's one of these soft sort of standards, is if the debtor cannot explain why they don't have enough assets to pay their debts, or where their assets went if they've lost any assets. And this is where it can get a little existentially weird. You may have a debtor who filed a loan application for a mortgage or an application for a lease 2 or 3 years ago. And they may list in that application assets and liabilities, and 2 or 3 years later they come to you and they need to file a bankruptcy because of some catastrophic uninsured accident or medical event, or they lost their job, or whatever the reason may be. And in the context of the bankruptcy, the recipient of that loan application says, you know what, 2 or 3 years ago when I got this loan application, you said you only owed $10,000, and your schedule show you owe $100,000. And the loan application that you filed says you have $50,000 worth of assets, but your schedules of assets and liabilities say you have $5,000 worth of assets. Explain why this is the case. If the debtor can't explain why now they have so much more debt or they have so many fewer assets, then technically their discharge can be barred. They won't get a discharge for any debt simply because they can't explain the difference between the loan application representations from 2 or 3 years ago and the current state of affairs. So one of the questions that you want to ask your clients is, okay, if you have credit card debt, and let's say you've got a Visa, and the Visa balance is $12,000. That $12,000 must have bought something. If they're showing you a list of assets, and it's only $2,000 or $3,000 worth of assets, where did the rest of the assets go that you bought for $12,000? Or did you get cash advance and dissipate the cash? And if you did, what did you spend that cash on? It is extremely rare that anybody seeks to bar a discharge on the grounds that the debtor can't explain where his or her assets went or why they don't have enough assets to pay their debts. But every once in a while, particularly in large, complicated individuals' cases, you will get that kind of litigation that's been brought. In consumer cases, it's extremely rare. I do not recall, in 30-plus years of practice, any consumer debtor ever being subjected to a potential bar to discharge because they couldn't explain the disparity between a loan application from 3 years ago and their current state of affairs. But it's in there, and creditors have the right, as does the Office of the U.S. Trustee, as does the Chapter 7 trustee, to seek to bar the discharge on that basis. So again, 727 lists a whole bunch of categories of things that can happen that would justify barring a debtor's discharge. 523 is a list of the kinds of debts, some automatic, some not, that are not dischargeable. Now, once the 60-day period expires for bringing an action to bar a debtor's discharge, assuming no one has brought an action to bar the debtor's discharge or asked for an extension of time to do so, after that 60-day period lapses, that's when the court will enter the discharge. And it happens automatically. As I said before, there's no thing you have to do in a Chapter 7 case to get the court to enter the discharge. In fact, it's the clerk that enters the discharge. So when your client says, how long is this case going to take? Let's very quickly talk about what the timeline is. You file the bankruptcy petition. You have all this paperwork to prepare up front, either before the petition is filed or during that 14-day period to file paperwork, or if that period is extended, whatever the extended period is, but it's all done before the meeting of creditors. 5 weeks or so after you file the bankruptcy petition, you have your meeting with the trustee, and that meeting starts the 60-day window for any party to come in and seek to bar the discharge. If nobody does, or that time is not extended, then the court will enter the discharge automatically. So how long is your client going to have a pending bankruptcy case? Roughly 4 months. During that 4 months, they will not have to go to court, barring something unusual happening. They will not have to appear in front of a judge. They will have one event to attend, and that event is that meeting face-to-face with the trustee in the U.S. courthouse in room 1207. And that will be it. Their responsibility will be to complete the paperwork, empower you to file correct, complete, and honest paperwork with respect to their assets and liabilities, attend the meeting of creditors. If the trustee wants to see a copy of their lease or wants to see a copy of their deed to their home, or something that shows the mortgage balance, or wants a copy of a Zillow so they can determine how much the debtor's real estate is worth, cooperate with the trustee, and then wait out the period to determine whether or not the discharge can be entered. The fact that somebody files an action under Section 523 will not delay the entry of a discharge, because the discharge itself says the debtor is discharged from all obligations except those which have been determined not to be dischargeable under 523. So the fact that the 523 deadline is extended, the fact that there is 523 litigation pending, or even if there has already been a 523 adjudication, the discharge will still be entered because 523 relates to a particular claim, not all claims. So the discharge will be entered, and effectively, at that point, the case is over from the debtor's point of view. Okay, any questions about discharge or dischargeability? All right, there is one important exception to the impact of discharge, and that is what's known as reaffirmation. The discharge that's entered is a discharge of the debtor's personal liability. Here comes some more Latin that we just groove on. The discharge discharges the in personam liability of the debtor for the debtor's debts. By contrast, for those of us who can vaguely remember law school, there is still in rem liability. What does that mean? A debtor who has a mortgage that files bankruptcy and gets a discharge is discharged from their personal liability for the mortgage. But the creditor's in rem right, meaning their right against their collateral, is not discharged. Therefore, their mortgage lien is not discharged, and that lien is going to simply ride through the bankruptcy and survive the bankruptcy. That means the secured creditor, without having to do anything, will preserve intact its rights against their collateral, but not their rights against the debtor. So if you have a property owned by a debtor in bankruptcy that has a mortgage on it, and they go through bankruptcy and they get a discharge, their personal liability is discharged, but not the creditor's in rem rights. So a year after bankruptcy is over, they default on their mortgage and the property goes to foreclosure. And the property is sold at foreclosure and it does not generate enough money to pay the mortgage. Normally, the creditor holding the mortgage that does not receive enough from the sale of the property at foreclosure has what's known as a deficiency claim. And that claim is enforceable against the debtor just like any other claim for payment. The difference is, if they've been through Chapter 7, that personal liability has been discharged. So at any point after the discharge has been entered, effectively the debtor can walk away from its collateral and have no personal liability. The creditor's right to go after the collateral survives, but the creditor's right to go after the debtor has been discharged. So the discharge, yes.
What happens to property taxes, the liability for property taxes on that situation?
Property taxes are not dischargeable.
So, I guess my question is that say like a debtor goes into bankruptcy because they're in foreclosure, they have no hope of saving the home,
Right.
They don't want to save the home, they say I'm not going to reaffirm the debt, and a creditor drags his feet on the foreclosure and doesn't complete the foreclosure until a year after, and the debtor's moved to Florida. Are they stuck with the property?
Have you
tax?
talked to my clients? Because I've got clients, yeah.
Just what you're dealing
I
with right
work for the
now.
National Consumer Law Center.
Ah, okay.
This is a reoccurring theme.
Yeah,
Okay.
that's
A little side note. The situation that the question refers to is where a creditor, for example, has obtained relief from the automatic stay for the purpose of foreclosing, or has waited until the case is over to start foreclosing, but doesn't actually foreclose. Or worse, conducts a foreclosure sale, is the successful bidder, but never records a trustee's deed, so that the debtor remains the owner of record for some indeterminable and interminable period of time. There's actually a thing, because this has become a recurring problem. It's called a zombie title. That's the technical term. That's the colloquial term for these things, zombie titles. Because the debtor still owns the property, but it's either subject to this delayed foreclosure or unconsummated foreclosure. And the short answer is, number one, remember what I told you, the discharge only affects pre-petition debt. As long as the debtor remains the owner of the property, then any real estate tax liability, any condo fees, any county assessment for failing to maintain the property, any slip and fall that might occur on abandoned property that the debtor's moved out of in contemplation of the foreclosure, any of that arises after the petition has been filed is not discharged. So you have somebody who, they say, I'm in default on my mortgage, I don't want to keep the property. It has real estate taxes, it has homeowners association dues attached to it, it has 2 mortgages, I am upside down in it, I don't want to burden myself trying to catch up, I'm going to walk away from it. The creditor gets notice of the bankruptcy, files a motion for relief from the stay for the purpose of foreclosing, and let's say it's, I don't know, Bank of America. Not to pick on Bank of America. And in the words of Johnny Carson, you know where I am, Bank of America. If you have a problem with what I'm saying, come and get me. But let's say it's Bank of America, and for some reason they decide, you know what, we own 1.5 million homes already. We don't want to foreclose. Even though we have the right to, we don't want to foreclose just yet. We want to see if we can find a buyer. Then we'll foreclose. We'll buy it at foreclosure and flip it to our prospective buyer. But we're not going to foreclose in the meantime. And the debtor's moved out because the debtor said, I'm not going to keep my home, I'm just going to move out. First of all, whoever told them that probably gave them bad advice. But a lot of people do this because they want to start their life anew somewhere else, like, for example, Florida. And we've got clients who did exactly that. They abandoned their respective residences and moved to Florida. For those people, they were continued liable for post-petition real estate taxes, post-petition condo fees. They have gotten sued for post-petition condo fees. And they called me up and said, what do we do? And I said, basically, you're liable for it. This is a post-petition obligation. So the bankruptcy courts have been, I don't want to say inundated, but bankruptcy lawyers have been trying to find a way to keep their clients from having to pay these post-petition obligations where it's turned into a zombie title. And the bankruptcy courts have said, look, we understand that the concept of a discharge is to give the debtor a fresh start, and that the creditor, by not foreclosing, is effectively interfering with that fresh start. But it's not a violation of the discharge for a creditor who has a right to foreclose, not to foreclose, and to leave the debtor liable for these post-petition events. And bankruptcy lawyers have tried all kinds of things to try and get their clients out of these zombie title post-petition obligations. And so far, nothing's worked. Okay, I have a theory, and I'm not sure that it's necessarily going to work, or that it necessarily hasn't already been tried and failed, or that I should be telling anybody this in advance, but maybe the National Consumer Law Center can help on it. But I believe that in DC, the failure of a mortgage company such as, Bank of America, to put in its loan documents that among its rights and remedies in the event of default is doing nothing, is a violation of the DC Consumer Protection Law and is consumer fraud. If you look at most mortgages, the mortgage in the default section says, in the event of default, at the discretion of lender, the lender may choose to, and then it lists all kinds of remedies that the lender may do. The lender may take possession of the property in anticipation of a sale as mortgagee in possession. The lender may commence foreclosure proceedings. The lender may seek the appointment of a receiver. But it never says the lender may do nothing, in which event the borrower continues to be liable for all ancillary owner's expenses. And I think that in light of the fact that it's becoming more and more common for lenders such as, I don't know, Bank of America, not to foreclose when they say they're going to foreclose, I think it's fraud on the consumer not to tell them that even though they may default and walk away from the property, and even though the concept of foreclosure is what they understand to be the remedy of the lender, that the lender may choose to do nothing and leave them continuing to be liable for the ownership costs of that property. I think that's consumer fraud. And as soon as my clients, who oddly enough now live in Florida, tell me that they want me to file that case, I'm filing that case.
I was just thinking, we had a case 4 years ago, she abandoned 2 properties in North Carolina, they still have not foreclosed. I think one of them is Green Tree, the other one might be Wells Fargo. She's getting sued by the HOA and by the mortgage company now at this point for the taxes and everything and the upkeep. Had a couple of clients who abandoned their property 3 years ago, and they're getting hit, they got hit by the city for not doing the grass, but Bank of America, I think that's the one on this one, still hasn't foreclosed, it's been 3 years, and that one's out in Baltimore.
And we had one in Fairfax where they hadn't foreclosed. The clients moved out, wanted their fresh start, moved out, and what was it, 2 years later? I think it was Bank of America. It might have started off as Countrywide,
yeah.
and which became Bank of America, and Bank of America still hasn't foreclosed. Yes?
Can't they just quit claim their interest
No.
to the bank?
And there's actually case law on this. Making a gift of title in the context of a secured creditor, a mortgagee receiving title to the property, requires acceptance of the gift of the quitclaim deed, of the title by quitclaim. And the mortgagee, if they're not going to foreclose, they're not going to accept the title. But that's something that's been tried over and over again. They just record the deed so it's out of their name,
Yeah.
and it doesn't work. Yes?
Even if there's not a voluntary, so for instance, if the client, has received a notice that they're gonna be foreclosed on and they send the mortgage company back, some kind of notification saying, I'm gonna voluntarily surrender, I'm vacating, even still that notice isn't sufficient
We've had clients who have brought the keys
to.
to the bank's representative and said, here,
Jingle mail? I think the lenders call that jingle mail.
jingle mail.
Yeah.
Well, the fact is, the mortgage companies will come in and change the locks.
Mhm.
It's still their
And
debtor's
still not
property.
foreclosed.
It's still not foreclosed, and the debtor's like, well, this is my property, I'll just go back in. They're like, nope, lock's changed. So they're stuck in limbo.
Oh, wow.
Would you advise a client who hadn't, well, whatever the situation, would you advise a client like that not to file bankruptcy until the foreclosure was complete?
I wouldn't advise them not to file bankruptcy. I would probably advise them, and it depends on the totality of the circumstances, qualification. I would probably advise them not to move out. Because if there's not going to be a foreclosure, you get to live mortgage-free. The only thing that you might have to pay is your HOA dues and your real estate taxes. But if they're not going to foreclose, I'm just going to live here mortgage-free. And remember, if they file bankruptcy, they have no personal liability. So at any point in time, when there actually is a foreclosure sale, that's when they can move out. Or they can even sit there as effectively squatters and force the purchaser at foreclosure to evict them, and then potentially raise defenses in landlord-tenant court and be there for an even longer period of time. We have several clients who in the past we have said, look, if you're not going to keep the property, live in it free until somebody throws you out. Just stop paying your mortgage. If you don't want to keep the property long-term, you don't have to move out now. The only difference is, because of the bankruptcy, remember we talked about this a little bit on Tuesday, because the bankruptcy is on their credit report, if they move out before the bankruptcy is filed, it's not yet on their credit report. It may be easier to find some place to move into. If they do it after the bankruptcy's filed, and therefore it's on that credit report, some landlords may be tougher on them in accepting an application for tenancy. So that's a strategic consideration to make. But yeah, I mean, we tell clients all the time, don't move out. If they're not going to foreclose, make them pay by letting you live there until they exercise their right.
But we make sure to tell them to pay your HOA fees, pay your property taxes, because those are the things that they'll forget to do, and then they'll come to me and they're like, I'm $12,000 behind, I don't know how this happened. Well, you didn't make any payments.
Right, and it's post-petition, which means...
So you're liable.
Yeah, you're liable, yes.
Similar question about post-petition debts. If someone has already gotten a bankruptcy discharge, moved out of the house several years ago, now has the foreclosure go through, even though they aren't liable for a deficiency, what about capital gains that might result from the sale? Are those considered post-petition?
No, they're considered
debts?
pre-petition, and they wouldn't be dischargeable because of their tax liability. Oh, I needed to talk about that, I'm sorry.
So pre-petition, but still not dischargeable?
Yes.
Okay.
Let's talk for a second about another category of 523 debts that are not dischargeable, and that's taxes. I'm sorry, I've forgotten about this when we were talking about 523. Taxes, most taxes that you encounter are not going to be dischargeable. There is effectively only one category of taxes that is dischargeable, and the shorthand way to think about it is old taxes. The formula under 523A3 for determining whether or not a tax is dischargeable is as follows. And this is a little bit complicated. First of all, with respect to a particular tax, there must have been a tax return that was filed, and it must have been filed on time. That's the first threshold. If a debtor owes taxes for a year for which he or she or they did not file a tax return, it is not dischargeable. If they didn't file it on time, the tax is not dischargeable. If they filed a return on time, and if there is no lien for the tax, and if there is no allegation of tax fraud, and again, there's a pretty high standard for tax fraud, not tax mistake, but tax fraud, then old taxes can be discharged if they meet a particular calendar requirement, which I'm going to explain now. So if there's been a timely return actually filed, and no tax lien and no tax fraud, then old taxes can be discharged. And here's the timing that makes it old. Every year, taxes are due to be filed by April 15th of the following year. So taxes for 2011 are due April 15th, 2012. Or if an extension's obtained, then it's August 15th, 2012. Or if another extension's sought and obtained, it would be October 15th of 2012. If, relative to the deadline for filing a particular year's taxes, a bankruptcy petition is filed more than 3 years later, then those taxes are considered old taxes, and if the other conditions are true, they can be discharged. So when might this occur? If a debtor files a tax return on time, but does not send in the money, or files a return on time and asks the IRS to determine their taxes, and the IRS sends them a bill after making that determination, and they don't pay it. And if there has been no tax lien, then if the taxes were due more than 3 years before the bankruptcy petition, those taxes can be discharged. So for example, we are now in, what are we in? We're June 2014. That means that taxes that were due before June of 2011 are old taxes. So since April 15th, 2011 is more than 3 years before today. If a bankruptcy petition is filed today, then the taxes for 2010, which are due April 15th, 2011, are more than 3 years old. And therefore, those taxes, if the other conditions are met, are dischargeable. Anything more recent than 3 years, or for which a return wasn't filed, or was filed but late, or involves tax fraud, or there's a tax lien on the debtor's property, means that the taxes are not dischargeable. So only one category of taxes are dischargeable, and that is filed on time, no allegation of tax fraud, no tax lien, and more than 3 years old when they became due. Okay. All right, this is a good time for us to take a break, and when we come back, we're going to start on the actual paperwork.